statute has not been repealed. If they were to be charged similarly in the future, they would be subject to the exact same prohibition. Thus, they have standing.
That is Attorney Thomas Magg during comments in front of the Illinois Supreme Court earlier this year when they argued two of his clients had their FOID card suspended improperly because they were only charged with a crime, they weren't convicted of a crime. And the Illinois Supreme Court essentially tossing the case out over issues of standing. What does all that mean? Well, we'll tackle that here with Illinois in Focus Daily. I'm Greg Bishop. Of course, like, subscribe, hit that notification bell each and every weekday morning, breaking out some things for you to know here in Illinois. So this case brought up through the court system, and it deals with the FOID card and a couple of individuals who had a FOID card, I believe a father and son. If I recall, they were approached by police who said that they had a report of an improper discharge of a firearm during some kind of celebration, and ultimately they were charged with crimes, but they were pleaded down to misdemeanors, and therefore their FOID card shouldn't have been revoked. And regardless, about a year or so, the FOID cards were revoked, and the case went all the way through the circuit courts, the appeals court, and all the way up to the Illinois Supreme Court. And I do want to get right to their conclusion here, and then we'll hear some of the arguments that were made during the trial. It wasn't a trial, it was the full panel of the Illinois Supreme Court hearing these arguments. But here's ultimately what the Illinois Supreme Court said on this case. For the foregoing reasons, we vacate the circuit judge's judgment, holding that section of the FOID Card Act is unconstitutional as applied to persons charged with a felony but not yet convicted of a felony, and enjoining the suspension of FOID cards as to those persons. In entering this disposition, we express no opinion on the merits of the parties' other arguments. As we are vacating the circuit judge's judgment in favor of plaintiffs, they are no longer the prevailing parties, so we also vacate the circuit court's order granting plaintiffs' petition to recover costs and fees. The cause is remanded to the circuit courts with directions to dismiss plaintiffs' First Amendment complaint. All right, where a plaintiff has no standing, the proceedings must be dismissed. This is so because lack of standing negates a plaintiff's cause of action. So, again, they didn't address the issues. As the Supreme Court said, in entering this disposition, we express no opinion of the merits of the parties' other arguments. But what were those arguments? Let's get right into it. And again, this was heard back in May in front of the Illinois Supreme Court here in Springfield. And Attorney Thomas Magg, he laid out the crux of the case in general terms.
There is a federal statute, 18 U.S.C. 922, N as in Nancy, I believe it's the exact quote, that prohibits persons charged but not convicted of felonies, not from possessing firearms. They can keep the ones they've got while they're under indictment or information, but prevents them from acquiring new firearms while they're under charge. That is what this case is about, is the state police interprets, and I think it's a reasonable interpretation of the statute, aside from constitutionality issues, that triggers the section N of the FOID Card Act, which requires suspension of FOID cards when a person cannot acquire a firearm.
So there was some discussion as well during the court proceedings in May in front of the Illinois Supreme Court about the U.S. Supreme Court precedents in cases like the Bruin case, the New York State Rifle Association v. Bruin case. And the attorney representing the state said the law in Illinois for the FOID card, as is being challenged in Magg's case, they say they're good with it. I mean, they're covered.
The Supreme Court is clear that the Second Amendment covers possession of firearms for self-defense by those considered law-abiding and responsible and not dangerous. This does not cover the plaintiffs because while they were under this felony charge, they had conceded that there was probable cause that they recklessly endangered others with firearms.
And again, the case centering around two individuals who fired off their weapons, I believe, into the ground. during a celebration of sorts, and police being called and them coming in and arresting the two. But the attorney for the state also talked about the Bruin test and the importance of finding analogous laws from what era exactly?
And then more broadly, the Bruin very clearly explains that the historical law and the modern law do not need to be identical. And the analogs that we presented here, obviously they're not identical because, it's been 250 years, but they're historical analogs about restricting a person's possession on a temporary basis, on, some in a categorical sense and some based on some legal process that is short of a conviction. Kind of with all of those different approaches, there clearly is, a historical basis supporting this law under the Bruin standard.
According to the attorney representing the state, but attorney Thomas Magg, representing the two individuals who had their FOID cards suspended for merely being arrested, not convicted, here's what he had to say about finding analogies in which era.
To look back at what the law was, depending on which sources you read, either at the time of the adoption of the Second Amendment or arguably at the time of the adoption of the 14th Amendment. I think the time of the Revolution is the more appropriate standard myself, but I understand there is some argument in the literature on that. And prior to 1925, as near as I can tell, there were no restrictions on even actual convicted felons possessing at least long arms.
So again, these arguments about analogous laws from the past are really driven by the U.S. Supreme Court's decisions saying that you have to look at the text, history, and tradition. And analogous laws from when exactly? Is it 1925? Is it 1864? Is it 1796 or 1776? So I think that's obviously something these courts are continuing to hash out, and we'll see a lot more on all kinds of different issues when it comes to the Second Amendment and what kinds of laws may be referred to from the past to justify having a law in place now, or the arguments that, hey, these weren't in place at all when the founding documents were penned, therefore they're unconstitutional. I mean, those seem to be really, at least the history, text, and tradition aspect of finding analogous laws, similar laws. But the issues really in this case, as we read in the conclusion from the Illinois Supreme Court in the opinion they issued on Thursday, saying that this particular law that's being challenged is moot, essentially. Here's the attorney representing the state talking about mootness and what's called standing. Does somebody actually have an injury that they can prove to show that they are the person to bring this case?
But then my final point, just to go back to the issue of standing, because again, that's really what the threshold issue of this case is about. The plaintiffs argue that they have standing because their FOID cards were revoked for nearly a year. But as this court has said, when we're talking about a declaratory judgment, seeking prospective relief, challenging a statute, there must be more than just, the courts use the language, a wrong committed and an injury inflicted.
So what's the injury, though? That was something else that was debated in the hearing in May. You had Chief Justice Teese asking Thomas Magg about where is this injury?
Where is the injury that triggers the ability to have bring a case that looks into the future?
The injury that triggers it is the revocation of the FOID cards.
In the past.
In the past.
Okay. I mean, that's trouble. I mean, you can see what we're saying. This lawsuit looks prospectively. It doesn't look back. It doesn't say, I was injured, therefore I have damages. It looks forward. What will happen in the future, correct?
It is seeking to prevent a similar injury in the future because of the damage that took place in the past.
So interesting arguments there, right? I mean, again, they were injured for about a year, he says. They didn't have their FOID card. They weren't convicted of anything. They pled guilty to a misdemeanor, which doesn't allow for the FOID card to be taken under some circumstances. So he's wanting to bring this case to say, listen, that provision of the law is still in place, and somebody else down the line can very easily be ensnared by it and injured by it. And that's why they're bringing this case from two individuals that had an injury, he says. But they don't now, right? Even when this case was filed, apparently they had had their FOID card reinstated. Justice O'Brien raising that question about what's considered a live controversy.
But the fact of the matter is that the time that this suit was filed, both of these individuals had active FOID cards. Is that accurate?
That is my understanding.
And that when that was challenged, the motion to dismiss and the motions for summary judgment, in the order of the trial court, the judge doesn't address that. He goes,
In this case, my clients, the appellees, actually had their FOID cards actually suspended for approximately a year, plus or minus, because of the imposition of this statute. The statute has not been repealed. If they were to be charged similarly in the future, they would be subject to the exact same prohibition. Thus, they have standing.
And didn't seem to sway the Supreme Court. I think it was a near unanimous decision in this case, with all the justices essentially saying here, again, we'll look at the conclusion in this 10-page report here that they put out the orders for. It says that for the foregoing reasons, we vacate the circuit judge's judgment holding that the FOID Card Act is unconstitutional because a lower judge said it's unconstitutional as applied to persons charged with a felony but not yet convicted of a felony, and enjoining the suspension of FOID cards as to those people. And entering this disposition, we express no opinion on the merits of other arguments. But the state, again, they said that the timing in this case is really where this is all about.
Yes, it's sort of an issue of timing. So because the plaintiffs had their FOID cards when they brought this lawsuit, there was no standing, and the inquiry just kind of ends there. If the plaintiffs had brought their lawsuit while their FOID cards were revoked, then we would have kind of a mootness issue. And I suppose if the court were to overlook the lack of standing here, it would then need to address the mootness issue and the mootness exceptions. But because those exceptions don't excuse a lack of standing, the court need not even reach those exceptions if it rules on the issue of standing.
Bottom line, this case not really going the way that the plaintiffs wanted it to go. And the Supreme Court of Illinois not really taking a position at all on the constitutionality of the firearm owner ID card, other than to say that the lower court's ruling is overturned and vacated. So we'll see what happens next with the FOID card here in Illinois. It's been around since, 1967? I got to do a deep dive into the legislative history of that. Follow me anywhere. Just search Bishop on Air. Like, subscribe, hit that notification bell for Illinois in Focus Daily with America's Talking Network here on YouTube.